Welcome to this explainer. Today we're looking at a pretty fascinating institutional shift in Pakistan's corporate justice system. We're diving deep into the Securities and Exchange Commission of Pakistan, the SECP, and specifically its appellate bench. It's actually an incredible story of how you take a totally legacy, paper-heavy bureaucracy and just transform it into a digital, highly efficient regulatory courtroom. It's like flipping a switch on corporate justice.
So it really all starts with this one core question, right? How does a country build a fast, modern corporate courtroom out of a totally slow, paper-heavy bureaucracy? Because honestly, this is the ultimate balancing act. On one side, you've got the immense punitive powers of the state. I mean, literally the ability to issue massive fines or yank corporate licenses overnight. And on the flip side, you have the fundamental rights of businesses, stockbrokers, and insurance companies who absolutely need a fair, impartial venue to defend themselves. The stakes for investor confidence here literally could not be higher.
Okay, let's dive into this. We're going to unpack this transformation in 5 distinct steps. First up, escaping the paper bureaucracy. Second, designing a fair tribunal. Third, anatomy of corporate justice. Fourth, clearing the historic backlog. And finally, the ultimate institutional gatekeeper.
Starting right off with Section 1, escaping the paper bureaucracy, from the Corporate Law Authority to the SECP.
To really understand how advanced the current system is, we kind of have to look at the absolute chaos that it replaced. Basically, before 1997, corporate tracking in Pakistan was run by a federal department called the Corporate Law Authority, or CLA, and it operated exactly like a traditional government ministry, just painfully slow, completely buried in paperwork. Imagine your business faces an arbitrary penalty or gets shut down. You had 0 internal ways to challenge it. Your only option? Take the government to standard civil courts, which, let's be real, could drag on for a decade. This bottleneck was completely terrifying to international markets. So under serious global pressure, Pakistan dissolved the CLA and birthed the modern SECP in 1997. But lawmakers knew this new watchdog was going to have sweeping powers. So they built this brilliant statutory escape valve right into the law, Section 33. This mandated an internal, quasi-judicial Supreme Court, the Appellate Bench.
Looking at the timeline here, that conceptual foundation was officially laid down in 1997 with the SECP Act. Fast forward a bit to 2003, and the actual daily operations, the timelines, the legal structures, all of that was formally codified into procedural rules. Then jumping to 2015 to 2017, we saw this massive jurisprudential expansion. The Securities Act of 2015 put the bench right at the center of insider trading and market manipulation cases coming off the Pakistan Stock Exchange. And the Companies Act of 2017 gave them the teeth to crack down on boardroom coups and illegal deposit-taking schemes. Finally, from 2024 to 2026, a total digital shift transformed literally decades of rulings into a transparent online public portal. A real game changer.
Moving on to Section 2, designing a fair tribunal, the mechanics of impartiality.
Now, the architects of this system faced a massive structural dilemma. Think about it. How do you create a genuinely fair internal court when the judges technically work for the exact same regulatory body that's handing out the fines? Well, their elegant solution is the 2-commissioner rule. See, the SEP is run by appointed commissioners who head up different operational divisions. So naturally, if an adjudicating officer under them issues a penalty, there's a baked-in conflict of interest. To solve this, the active appellate bench absolutely must consist of 2 entirely different commissioners who had 0 structural involvement in the original investigation, the show cause notice, or the penalty order. I cannot stress this enough. This specific, brilliant rule is the absolute cornerstone of the bench's fairness and legitimacy. And hey, if those 2 independent commissioners ever deadlock, the matter just goes to a 3rd neutral commissioner to break the tie.
So what exactly do they hear? The bench has a very precise jurisdiction. You can appeal Major Companies Act defaults, anti-money laundering breaches, which by the way is absolutely crucial for Pakistan's FATF compliance, insurance solvency disputes, and Securities Act malpractice, like market rigging. But under Section 33, certain actions are strictly off-limits. You cannot appeal purely administrative directions, internal reviews, the mere decision to commence legal actions, or interim orders that don't actually resolve the core case. It's a highly, highly specialized form.
Which brings us to Section 3, Anatomy of Corporate Justice, pulling back the curtain on the registry.
All right, stepping away from the judges for a second, there is a super fast-paced, high-stakes administrative engine that actually runs the day-to-day operations. Inside this registry, the culture is aggressive and totally digital first. They don't even use standard government pay scales. They use autonomous alphanumeric grades, A to H. Because frankly, to regulate multi-billion rupee conglomerates, they need top-tier talent. So they actually use executive headhunters to pull specialized corporate litigation experts straight out of the private sector. And before anyone is even hired, there are intense criminal and higher education commission degree clearances. The workflows? Heavily paper-reduced, relying on the SECP's digital e-services portal. And crucially, given the huge financial impact of these cases, staff face rigorous conflict of interest declarations. It forces immediate recusal if they have any personal connection to a company on the docket. No exceptions.
Let's see how this all builds into a highly disciplined life cycle for an appeal. Step 1. The initial impugned order gets issued by a lower regulator. Step 2. The aggrieved company has a strict, no-nonsense 30-day window to file their appeal with the registry. Step 3. The bench operates under intense pressure with an aggressive 45-day resolution target to actually hear arguments and issue a final written decree. And finally, Step 4, if a corporate entity is still unsatisfied, their absolute last resort is a 60-day window to escalate the matter as a statutory appeal directly to the provincial high court.
All right, Section 4, clearing the historic backlog, a victory for digital due process.
So, by the early 2020s, despite its really efficient design, the bench ran into a compounding problem. Corporate entities figured out they could exploit procedural delays to basically keep their enforcement penalties frozen for years. Not great. But under modern leadership, specifically the institutional direction of SEPC Chairman Akif Saeed and Registry Director Amina Aziz, they launched a super aggressive performance push. Which brings us to this massive number, 124. That is the historic volume of complex, high-stakes appeals the bench suddenly disposed of. They effectively wiped out a decade of backlog stretching all the way back to 2011. Just an incredible clear-out.
Let's break down that macro statistic a bit, because these were definitely not simple clerical errors. This clear-out included 48 critical anti-money laundering cases, 34 major corporate act defaults, 22 complex insurance solvency conflicts, and 15 capital market manipulations. The crucial takeaway here is that they acted with real, decisive authority. Out of those cases, they upheld 113 decisions to protect the market, sure, but they also completely set aside 11 orders, which proves they aren't just some rubber stamp for the regulator. They demand real bank trails, clear evidence, the whole shebang.
And here's the kicker. They didn't just clear this massive backlog sitting at their desks in Islamabad. In a really vital operational shift, commissioners regularly travel out of the capital to hold active tribunal sessions directly inside regional company registration offices in places like Karachi, Lahore, and Multan. These circuit sittings really humanize the whole legal framework. They physically accommodate smaller businesses, regional textile mills, and local brokers who honestly just can't afford the financial and logistical drain of traveling all the way to the capital. It's a huge deal for access to justice.
Finally, we arrive at Section 5, the ultimate institutional gatekeeper, balancing power and fairness.
So why does this all matter to you, whether you're a market observer or a corporate professional? Well, the bench acts as this absolutely vital escape valve. By intercepting thousands of corporate disputes internally, it completely prevents immediate bottlenecks in Pakistan's formal high courts. At the exact same time, it ensures that global corporate fraud, insider trading, and money laundering are held strictly accountable, but without suffocating the actual business community in red tape. It essentially proves that rigorous state regulation and transparent corporate fairness can in fact successfully coexist.
Which leaves us with this final thought. As global markets digitize at just breakneck speeds, how do we continue to balance the immense punitive powers of the state with the fundamental rights of businesses? The SECP Appellate Bench shows us one highly effective, real-world model of institutionalizing due process. It's a truly fascinating look at the machinery of justice and hopefully a reminder to keep digging into how modern corporate tribunals like this are actively shaping the financial world.